Thousands reacted to Friday's reversal of Roe by the U.S. Supreme Court. For months leading up to that decision, many different groups disconnected to the unborn feared what that reversal might mean for them. Now that reality is here. Shannon Minter, legal director of the National Center for Lesbian Rights, with me now live. As same-sex marriage is one of the current legal rights that may fall in the wake of Roe. Good morning to you.
Good morning.
We talked about this issue last fall when the disappearance of Roe was a maybe. When the Supreme Court ruling came out Friday, what went through your mind as it related to the implications for same-sex marriage?
I was really shocked. I did not think that the court was going to cast marriage equality into question, and they have done that. They have done the unthinkable. Justice Thomas, in his concurring opinion, expressly called for the court to reverse Obergefell, and there's very weak assurances in the majority opinion against the possibility that the court may do that. And the most alarming, I think, was the dissenting opinion said repeatedly, look, they're going to do more of this. These other rights are on the chopping block. So this has been a real wake-up call.
I'm just talking about, I was going to ask you about Obergefell v. Hodges. When you and I were talking about these possible implications last fall and others were trying to, really get the word out that this was a possibility, there seemed to be a lot of, you're kind of making a mountain out of a molehill comments that were made during that time. And as you mentioned in that concurring opinion, Justice Thomas suggested that other key decisions like same-sex marriage should be revisited. Also, same-sex sex, the 2003 Lawrence versus Texas case. So the worry wasn't just a lot of groundless grousing.
No, this is unbelievable. I mean, I will confess, I was among those who really thought that we shouldn't be too quick to worry that these fundamental freedoms that have been now so well established and that millions of LGBTQ people have come to rely on would be up for grabs. I did not think the court would go there, and they have done that. I mean, the writing's on the wall. They put it on the table. I am very deeply concerned, more concerned than I have ever been in 30 years of working on these civil rights issues for the LGBTQ community.
And let's review. Many of our viewers won't understand how same-sex marriage and abortion rights reversals could have anything to do with each other. But there was an amicus brief filed in the Mississippi case just decided, Dobbs v. Jackson Women's Health, a brief filed by Jonathan Mitchell, the man behind the Texas heartbeat law. And that brief directly challenges marriage equality?
Yes, that's right. I mean, what the court has incredibly held is that the only rights that are protected by the U.S. Constitution are rights that were established in 1868 at the time the 14th Amendment was ratified. That is a shocking move for the court, and that puts any number of rights in peril, certainly the right to contraception, the right to sexual freedom, and the right to marriage equality.
In suggesting a reconsideration of these precedents, Justice Thomas wrote that any substantive due process decision, such as in these cases, is, quote, demonstrably erroneous, and that the court has a, quote, duty to correct the error. For us non-lawyers, how are these due process issues?
Yeah, so that simply means that historically the court has looked at the broad protections in the 14th Amendment that guarantee due process to everyone. And that has been the basis for the court holding that there are certain fundamental freedoms that are just so essential, important in a person's life, that we want individuals rather than the government making decisions about how to raise your children, who to marry, whether to start a family, what your family looks like, whether to marry a person of the same sex or the opposite sex, whether to carry a pregnancy to term. And these have all been protected under the doctrine of substantive due process. And the court has now cast all of those rights into question and said, oh, we think that the due process clause doesn't protect any of these fundamental freedoms. Unless it was a right that was recognized in 1868, our Constitution is not going to offer any protection.
Justice Coney Barrett, Brett Kavanaugh, and Neil Gorsuch said during their congressional confirmation hearings that they believe Roe was settled law and then now have acted in opposition to that. Any merit in the argument of those who say those justices need to be impeached, in your opinion, for lying under oath?
Look, I think that should be taken very seriously. It is shocking to have Supreme Court nominees stand up before the whole country and before the entire Senate and make assurances that they respected Roe as a precedent, and then to turn around and reject it so precipitously. I've never seen anything like that happen, and I would think that it's something that would be taken very seriously by the Senate.
And then for your group, what is the next step? Is there something to do now that you all are considering?
Well, we will certainly be playing legal defense, and we're very concerned that states, more conservative states, may take action, as Justice Thomas invited them to do, to try to undermine marriage equality for same-sex couples. We'll certainly be poised to challenge that. But one thing we know now is we cannot count on the U.S. Supreme Court to protect us. So we are calling on LGBTQ people, allies, every person in this country who cares about these fundamental freedoms and who cares about families. We want to protect our families. We want to protect all families. And I think what we really need to see is the political calling out of this decision. And we all need to be contacting our federal representatives and telling them, hey, this is not okay. We need Supreme Court reform, and we need it immediately.
Alrighty, thank you so much for your insight this morning. We appreciate you.
Thank you.